Good morning, everyone. Welcome to Assembly Judiciary. Welcome everyone here in Carson City, those watching online, and anyone in attendance in Las Vegas. With that, Committee Secretary, will you please take the roll?
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson. Here. Hardy. Here. LaRue Hatch. Marzola.
Present.
Moore.
Here.
Nadine.
Present.
Orton Liquor.
Here.
Roth.
Here.
Urick.
Here.
Chair Miller.
Here. And please mark Assemblywoman LaRue Hatch present when she arrives. She'll be joining us momentarily. Just a few quick reminders. Please turn off your electronic devices. Of course, committee information is available on the agenda that is posted on Nellis. We will have public comment at the end of today's meeting. For anyone making public comment or testifying on a bill, we ask that you keep your comments to 2 minutes. I will also provide the phone number now for anyone interested in calling in later. The phone number is 1-888-475-4499, and the meeting ID for today is 889-0429-3613. Again, asking presenters to keep their presentations to 15 minutes per bill if possible. And with that, we'll go ahead and get started on this very restful 9 a.m. Monday morning. So we have 2 bills today. The first one is a hearing on Assembly Bill 15, which revises provisions relating to medical fraud. With that, I will welcome the Attorney General up, or whomever is presenting. I will welcome the Chief of Staff up. And please, Chief, when you're ready, introduce whoever's participating in your presentation and begin. Oh, also for the record, please say your name and spell it.
Thank you so much. For the record, Teresa Benitez Thompson with the Office of Attorney General, first name Teresa, last name Benitez, Benitez Thompson, And from our office, we have with our Medicaid Fraud Control Unit, Senior Deputy Attorney General Jessica Perlich, and she is down in the Las Vegas office. I'm going to be Vanna White pushing us through the PowerPoint today, otherwise she'll be giving the content of the presentation.
Good morning. Jessica Perlich, Jessica Perlick, and I appreciate the time and thank you for having me. As far as the PowerPoint is concerned, I will not rely on it completely. It has been provided for your information, but I'll give you some high-level overview just so that there's some context to the bill that we're reviewing today. Essentially, what we wanted to do with the Medicaid Fraud Control Unit is introduce you to who we are and what we do. We are a division of the Attorney General's office made up of attorneys, law enforcement, civil investigators, auditors and analysts, and support staff. We combat fraud within the Medicaid system, but we are not actually Medicaid. We are an independent agency that is 75% federally funded by a grant through the federal government. Excuse me. We investigate provider fraud. We do not investigate recipient fraud. So when we are doing investigations into the Medicaid system, we are looking at providers who are undermining the system in a variety of ways. And that could be through typical fraud, what I would call typical fraud, which would be something like upcoding a doctor's visit from what should be billing for a 45-minute code when really it's only 10 minutes of time that they've been seen for service, a pharmacist overbilling or using the wrong billing mechanism for a particular pharmaceutical, individuals who are billing for services that have not been provided to the recipients that they are claiming to have seen. There is a variety of fraud that we encounter and that we prosecute. We do have civil litigators and we have criminal prosecutors. And so within our unit, we do civil and criminal cases. The fraud cases that I've spoken about could be civil or criminal. We also have the opportunity we have the authority to go into any facility that receives Medicaid funds, and we can review the treatment of elder and vulnerable adults. So elder adults are going to be people over the age of 60. Vulnerable adults are anyone over the age of 18 who need assistance with their activities of daily living. So for instance, someone who lives in a long-term care facility who may have developmental issues or delays. When we are doing those investigations, that is into abuse and neglect of those individuals within facilities that receive money from Medicaid. And finally, Teresa, if you don't mind switching to the next slide. And I apologize, I actually missed a slide, but that's okay. I can go, one more slide. Thank you. The third and final type of case that we deal with or that we review are called qui tam cases. And those are essentially whistleblower lawsuits. They're brought by private individuals against large scale or small scale companies, but in our experience, they are typically large scale companies, national companies that have a variety of branches throughout the United States. These are cases that we work jointly with our U.S. Attorney's Office, the Department of Justice, and other attorneys general from across the country. And so when we are doing those cases, they are typically under seal while they're being investigated. They could involve a variety of fraud schemes against a variety of types of providers or anti-kickback schemes or any other attempt to defraud the Medicaid and Medicare system in those instances. Because those are joint cases, we typically are dealing with both Medicaid and Medicare, but in our purview, we are only dealing with Medicaid within the state system. And so that's actually, with that, it makes the most sense to go ahead and go into the details of the bill, and you will have this PowerPoint for your reference later on, but the bill itself is reasonably straightforward and related to what I've just talked about. The first portion of the bill is Part 1 seeks to expand our existing authority to issue civil subpoenas in our civil investigations. As of right now, what we can do is issue a subpoena to a provider that is the target of an investigation, and we can obtain records. What we are asking to be able to do is also include the ability to have those providers come in for sworn depositions and to serve interrogatories. Now, this is something that is done in other states. We actually modeled our proposed amendment on Massachusetts' existing statute. Ohio is another state with a large Medicaid population that has a similar statute. But most importantly, when we are working with our federal counterparts in the qui tam litigation, they are issuing what are called civil investigative demands under their statute of 31 USC 3733. And their civil investigative demand statute includes all of the information that we are seeking to add to ours. So this is not something that would be unusual to practitioners in this arena. This is something that's very standard, especially within federal investigations. The benefit to us is that we would be able to fully flesh out allegations of fraud within the system prior to having to make a determination of whether to file a civil complaint. There's actually an ongoing benefit to the defense if they can have a more fulsome discussion and interaction with us throughout the course of our investigation. I was recently at a conference in Washington, D.C. with a variety of practitioners, including defense counsel, and they spoke very positively about the ability to interact with investigators during the course of the investigation through the federal CIDs, because they see it as a way to help their clients start remediating action that may have led to the investigation in the first place. And it creates just a better interaction between the investigation, between our office and the defense bar. And additionally, it would allow, by having this opportunity to do this prior to filing a complaint, we would actually be able to give the benefit to the defense of keeping it out of the public sphere for a longer period of time. If we file a complaint and we start going through a traditional litigation process, that is all part of the public record. For some of these cases, it may not be what it first appears. And so being able to do a more confidential investigation is to the benefit of everyone. The second portion of our bill is addressing the Nevada False Claims Act. The Nevada False Claims Act conforms in large part to the Federal False Claims Act. And because it does, Nevada actually receives a monetary financial benefit. When we recover funds during a case, whether a criminal or civil case, we have to do what is called the FMAP and SMAP split. We send back certain funds from recovery, from restitution penalties back to the federal government because they do partially fund our unit. And then we maintain a portion of those funds for the state of Nevada. The current split is 51-49 in favor of the federal government. That is because our Nevada False Claims Act conforms to the federal statute. However, recently, the Nevada Supreme Court issued a decision in a case called Orbitz, in which they highlighted a distinction between the Nevada False Claims Act and the Federal False Claims Act. In the Federal False Claims Act, there's a prohibition against an individual bringing a lawsuit in which there is already an existing lawsuit against the same actors, the same agencies for the same allegations. The Nevada statute prohibits a private actor from maintaining that lawsuit in the same context. Because of that distinction, there is a possibility we could be found to be out of compliance with our duty to conform to the federal statute. If that were the case, then our FMAP and SMAP split would actually be reduced by 10%. And Nevada would only be able to retain 39% of recoveries as opposed to 49% of recoveries. So what we are seeking to do in part 2 of this bill is simply change the language of the Nevada False Claims statute so that instead of in section 3 where it says an action may not be maintained, we would suggest that it be changed to an action may not be brought. This would be in conformity with the federal statute and keep us in compliance and ensure that funds stay in Nevada where they belong. And finally, the third portion of our bill is in reference to one of our criminal statutes. Under 422570, we have a records offense. Any provider who is enrolled in Nevada Medicaid is required to keep certain documents and notes of services to ensure that they have met the requirements to bill Medicaid for the services they've provided. If they do not, we can criminally prosecute them under 422570. However, right now, there's only the ability to prosecute and convict of a gross misdemeanor offense. What we are seeking to do in this bill is add the option of a misdemeanor offense. And that would be for a couple of different reasons. One is that this would actually conform to our existing Medicaid fraud statute in 422540, which has the option of a gross misdemeanor, and felony within the statutory scheme. And so we would just be seeking to include the lower level offense in our records offense. And it also helps us to more conform the punishment to fit the crime. If this is a lower level records offense that we're talking about, it would make sense that someone who is guilty of that could be convicted of a misdemeanor rather than a gross misdemeanor. It also allows our prosecutors to have more opportunity for negotiation with defense counsel. It provides defense counsel an opportunity to seek out a lower level offense for their client. And it allows more options for the parties as these investigations go on. So I believe that was within 15 minutes, but I'm happy to answer any questions you may have.
Thank you for your presentation. It was indeed within 15 minutes, and I will also compliment you for not reading the PowerPoint verbatim. The heads are nodding here in Carson City, so thank you so much for that. We do have a few questions. We will start with Assemblymember Gray.
Thank you, Madam Chair. Since there's a conglomeration of federal and state funds and the feds are putting in the 51%, can they be charged either federally or criminally, or if one goes forward and fails, can they be charged by the other side?
Excuse me. We have done We have done some joint cases with the feds, and typically they've gone forward separately. The funding that we receive is not specific to, sorry, I'm trying to think of how best to answer your question. So the 51-49 split is more about recovery after the fact for our investigations, whether civil or criminal. We can refer cases over to the Department of Justice, HHS, OIG, FBI, and they can do their own cases. They have taken cases from us before, in which case they would keep a complete, the complete balance of recovery. So this is just for cases in which we've initiated the investigation.
Thank you.
Thank you. Our next question is from Assemblymember Dahlia.
Thank you, Chair, and thank you for the presentation. I'm just curious about Section 3, the piece about the $650 dividing line between the misdemeanor and the gross misdemeanor. Is that based on caseload, or is that based on trying to conform with another part of the statutory scheme? Thank you.
It is conforming with another part of the statutory scheme. I believe the Medicaid fraud portion also has a 650 split. And so there is a different portion of the statute that would be in conformance with.
Thank you. And will you please remember to say your name for the record? It's really one of the most difficult things I have to ask people to do. So if you could just say your name, especially because if Chief responds, there may be, we just want to make sure we have the right person. With that, I'm sorry, Assemblymember, were you finished with your question?
Yes, thanks.
Okay, thanks. We will move to Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. My question is regarding the investigation and physician office. What is the criteria for the Medicaid fraud that you think that you have to call and go and do the investigation? Because as my understanding, the physician offices are already hit and the providers, they are not happy, and we need more physicians in our state of Nevada. So what is the basic criteria that you think that this is how you are going to proceed, and you're going to tell them that they need to provide the records and they have to, is that a single, any person can go and tell the Attorney General office, a patient, that they are not happy? Is that a single complaint or is it a series of complaints? What is the process? Thank you.
We have a robust referral process that we review referrals on a biweekly basis. We receive them from a variety of sources, not just single patients who are dissatisfied with service. We do seek to look for anything that would corroborate that information. So we work with a variety of partner agencies, such as the Bureau of Quality Care and Compliance, BHCQC. We work with Adult Protective Services, Aging and Disability Services. We also work with the Surveillance and Utilization Review Unit within Nevada Medicaid, and we work with the review units within the managed care organizations themselves. So we are receiving any referral that we take from a variety of sources, and we are doing an initial investigation to corroborate the information prior to going directly to the physician or to the office. We do understand the need for quality care within Nevada, and we don't want to undermine that. However, we do want to ensure that bad actors, and especially bad providers who are not doing the work that they have said they are doing for this vulnerable population, is held accountable when that's the case.
Can I do the follow-up question, Madam Chair? Certainly. Thank you, Madam Chair. I just want to make sure that, so that's a series of complaints that you will receive, only then you will take the action.
Can you?
Were you
I
able?
apologize. I think the sound went off.
Okay, thank
So
you.
I didn't actually, I could see speaking, but I couldn't hear the question.
Okay, so I will repeat my question.
Assemblymember, is your microphone on? Yeah, or is
Yes,
it? Okay.
it's on.
And then we're also looking at the back of Las Vegas. Can we get There we go. All right, now we're all set up.
Thank you. Thank you. So my understanding is that it's a series of complaints that you will receive from different sources, only then you will go ahead and investigate.
There could be a single source complaint, but we do some due diligence to corroborate the complaint rather than going directly in. And so we already have the ability to go and request records from providers. That's a very standard requirement, especially if they are Medicaid providers. They're required as part of their enrollment to allow to allow investigators to come and request records. However, this would just extend our investigative abilities into interrogatories, and that's typically when an attorney is already involved as well. That would be something we would be taking into account in utilizing this action. Would be the stage of the investigation, whether we've corroborated the allegations, the seriousness of them, how much more information we need beyond what we've already obtained through the records.
Okay. Thank you.
Thank you. Our next question is from Assemblyman Urick.
Thank you, Chair. Good morning, and thank you for that presentation. My question is, I believe you said this is legislation that's modeled after Massachusetts and I think Ohio, something similar. I can imagine, and by the way, I applaud the effort. Let's stop all abuses of anything dealing with Medicaid. But I'm curious in those jurisdictions how long that has been in place, and due to some of the increased administrative burdens and costs associated with responding to some of the discovery requests that are filed in these types of cases, have we seen any decline in the number of providers who remain enrolled and participating in Medicaid at all? Do you know that, or is that a potential concern?
Unfortunately, I don't know the answer to that question. In terms of how long the legislation has been present in the other states, my sense is that it's been in place for a number of years. I would have to go back and check exact timelines. But in working with these attorneys general's offices from around the country, I know that they've been doing this work, especially on the civil side, for a little bit longer than what we've been doing in our office. We have been building up our civil side. And so this, and I apologize if I didn't make this clear before, this is a civil investigative authority that we're talking about, not criminal. So anything that we're talking about a civil investigation, keeping it out of the criminal context. In terms of provider numbers and enrollment, it's not something that I am concerned about at this point. I don't have numbers on that for you. It's something we could try to find out, but my sense is if you are already a provider of Medicaid, you know your obligations, and this is just something that would be part and parcel to that. If you're acting above board, in theory, it's not much more of a burden than what you already have to do.
Yeah, that's. I appreciate the clarification on that. And I imagine those numbers are pretty readily available. And if you guys have the opportunity to provide, I would really be interested. I understand you're saying you don't think it's a concern. I mean, certainly for those that are doing the right thing, we get it. They're doing the right thing. But I would be interested to know if we can anticipate, if this was to be passed, that we would see a decline just due to the cost, not because they're bad actors and like, okay, now it's going to cost me, but due to the investigations that are occurring and having to expend this, if we can anticipate anything like that, those numbers would be greatly appreciated. Thank you.
Okay. If that is something that we can obtain, I will work to provide them. I would say just one more response, which is the administrative burden that those providers may have is already existing if they have any kind of federal investigation into them, because this is very standard with what the federal investigators already do. So if they've ever encountered that on the federal side, if they've ever had to work with OIG, HHS, it's exactly the same type of investigation. It's just giving us the authority to do the same thing and perhaps not enter into the federal system. So I will see if that is something we can find, but that would be just one more response to that, though, in terms of why I'm not concerned.
If I could add, please, Chair Miller. Thank you so much. Through Chair Miller to Assemblymember Urick.
Please go direct.
Teresa Benitez Thompson for the record. In addition to that, I think what might be helpful is we can provide you a little bit of history on some of the prosecutions that Medicaid Fraud Unit has had and some of the examples of where they have intervened, because the type of providers that they go after it's pretty egregious examples of abuse and neglect within the Medicaid system. And so I think that might help put it into context as well, so that you understand the the types of actions that they're looking at, the types of actors I would say that they're looking at.
Thank you for that. Our next question is from Assemblymember Moore.
Thank you, Chair. My question was just answered. Thank you.
Perfect. Then our next question is from Assemblymember Gray.
Thank you again, Madam Chair. So when you guys are looking at charging somebody with a misdemeanor or gross misdemeanor or anything criminal, who are you guys actually looking at charging? I mean, there's so many people that come in contact that are responsible for record keeping in a medical office that it's kind of, a hit and miss. You've got, records managers, you've got office managers, you've got the clerks, you've got, the doctors who are required to input stuff. Sometimes you have coding clerks. So I just really wondering how you guys are going to determine who to actually go after.
So unfortunately, I'm not a criminal prosecutor, so I'm not as clear on how they make those prosecutorial determinations. What I can say is that in the instance of there is a part of the statute, I believe it's NRS 422530, that imputes knowledge and responsibility on any owner of a facility or of a practice for criminal action that is taken under them. And so it would be, when we're talking about records offenses, we are talking about offenses in which there are no records to support the services that they have claimed to render, or they are so vastly under supported that it has risen to a criminal offense. Within those offices, I can get additional information for clarification from our criminal prosecutors, but it comes after a significant amount of investigation to determine who actually is at fault.
Thank you. Madam Chair, a quick follow-on?
Sure.
With regards to that, I mean, I agree with you, like with the office manager, or the owner of the practice, the vicarious liability through what their employees are doing. Where I differ, though, is the criminal case as opposed to a civil liability. If you could get us that information. I had a question that just kind of skittered away, but I would, before I could support this bill with a vote, I would really need to know who the target would be.
And if I could clarify, are we referring to, I know that you stated that you would get us the numbers, but are we speaking on the referrals that are received or the actual complaints?
Whoever they would wind up charging with the criminal offense, ma'am.
Okay.
So the second part they were talking about misdemeanors, gross misdemeanors, charging, for not maintaining the records properly.
Okay, so we're looking for the numbers of how many actual complaints, meaning you've gone forward with investigation, because I know earlier it was clarified very well that a referral could come from anyone, any one person, any one organization, but then there's the due diligence to do a little bit more investigation to ensure that there's something behind this than just maybe dissatisfaction or retribution. At that point, once it's deemed that, yes, there's something worth looking into here. So just to clarify again, you want the referrals or the actual complaints, or maybe the terminology we're using is mixing us all up.
Yeah, and I don't think this really has any bearing on how you guys receive the complaints or the referrals. Any of you guys decide to go forward with a prosecution, I guess it'd be a better way of stating it if who you guys are going to charge, criminally at that point.
Thank you for that.
I do believe I understand the request. The other thing that I can say in response, though, is that in my knowledge that I've gained from speaking to our prosecutors, this records offense is typically a negotiation tactic from the defense side, seeking to avoid an actual conviction for Medicaid fraud, because the records offense does not contain the words fraud or falsifying documents or anything like that within the language of the text. And so it's, for lack of a better description, more palatable for the defense bar to take a records offense gross misdemeanor than a Medicaid fraud gross misdemeanor. And so that is one tool and one use of it. whether or not we have a specific charge against a specific person in an existing criminal complaint is something I would have to find out.
Aaron Ford for the record, Madam Chairwoman. Thank you so much, and Senator Gray, thank you for your question. Just a couple of reminders here. The first of which is, as my colleague Ms. Perlick has indicated, the first part of this bill is civil in nature. I suspect you're talking about Section 3 of the bill. And what I wanted to remind everyone is that the vast majority of Section 3 already exists. The ability to prosecute exists. What we're attempting to do, as you've heard me say before, in our office, our job is justice. And we look to associate justice with ensuring that the punishment fits the crime. Right now, we don't have the ability to charge a misdemeanor. It must be a gross misdemeanor. So whomever it is that we are investigating at this juncture may get a little harsher justice than was necessary. And so what we're looking to do is to provide the ability for this office to effectuate justice in the way that is most appropriate under the circumstances, irrespective of what the statute currently says. We look to allow a misdemeanor charge to take place here, and that decision-making process won't change and hasn't changed relative to the ways in which the law currently exists and allows us to charge.
Thank you, Mr. Attorney General, and thank you for the answers.
Thank you. Our next question is from Vice Chair Marzola. You think you're okay? All right.
Yeah. My question was answered.
Okay.
Thank you, Chair. I think.
I think
So, okay. Just,
I think it was answered, but since I have the mic, let me
Yeah.
go ahead.
just so I can clarify. So I guess what I would like to request is a list of how many referrals you get in a year. So let's say 2024. In 2024, how many referrals, how many complaints were actually filed civilly, and how many complaints were actually filed criminally? Do you keep those stats?
We do keep stats like that, yes.
Perfect. If you can provide that to the committee secretary so Chair can pass it out, that'd be amazing. Thank you.
Teresa Benitez Thompson for the record through Chair Miller to Assembly Member Marzola. So we do have some of that information in our 2022 to 2024 biannual report, but what we can do is update that information because that's required to be published in the even number year before the legislature, August 1. So really those numbers are contemporary up until past July, so we can bring them contemporary up until today and share those with you.
That would be great. Thank you so much, and thank you, Chair.
Thank you. With that, not seeing any additional questions, I will go ahead and open it up for testimony in support of Assembly Bill 15. Again, just a reminder for everyone testifying to please state their name and spell it for the record, and please keep your comments to 2 minutes. So with that, is there anyone here in Carson City that would like to provide testimony in support of Assembly Bill 15? Anyone there in Las Vegas? Broadcasting, please open the lines.
If you would like to testify in support of Assembly Bill 15, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in support at this time.
Thank you. With that, then I will open it up for testimony in opposition of Assembly Bill 15. First here in Carson City. Anyone in Las Vegas? Broadcasting, will you open the lines, please?
If you would like to testify in opposition to Assembly Bill 15, please press star 9 now to take your place in the queue. There are no calls wishing to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony. Anyone here in Las Vegas? Oh, we're in Carson City, huh? Anyone here in Carson City? Las Vegas? Broadcasting, will you open the lines, please?
If you would like to testify in neutral of Assembly Bill 15, please press star 9 now to take your place in the queue. There are no callers wishing to testify in neutral at this time.
Thank you so much. Then I will welcome the presenters back up. And no one has any final words? Okay, thank you. Then I will go ahead and close the hearing on Assembly Bill 15. Our next bill presentation today is on Assembly Bill 45, which revises provisions relating to certain public bodies. Also, members, there is a proposed amendment, if you pulled that, and I assume we'll be presenting off of that. And so with that, whenever you are ready, please introduce yourselves and proceed.
Thank you so much. Good morning, members of the Assembly Judiciary Committee. I'm Teresa Benitez Thompson, for the record, Teresa, last name Benitez Thompson, Benitez -THOMPSON, Chief of Staff to Attorney General Ford, here to present Assembly Bill 45. Next to me, I have the Ombudsman on the Committee of Domestic Violence, Sexual Assault, with Nicole Riley, and we'll be speaking to Assembly Bill 45. So the Advisory Committee on the Rights of Sexual Assault Survivors was established in AB 176 in the 2019 session. The Advisory Committee had two main objectives that they were tasked with and had to get accomplished. First, to create a document explaining the rights of a survivor pursuant to the Sexual Assault Survivors Bill of Rights, and then to share that document and make it available to medical providers, law enforcement officials, and prosecutors. Second was to distribute $150,000 in each fiscal year of 2019 and 2020 to award grants of money to organize, train, and recruit advocates for sexual assault, and that was a one-time shot of funds. The Advisory Committee set to its work and we believe has accomplished their tasks. First, to note about the one-time shot of money that came. The first $150,000 was actually reverted back to the legislature during the 31st special session via Assembly Bill 3, Section 61. The Office of Attorney General, realizing the importance of this work, identified other grant dollars to supplant the funding, and all dollars in the end ended up being appropriated. The results of this work that those dollars funded can be found in the September 1st, 2020 report to Legislative Council Bureau, as well as a document titled AB 176, Training the Trainers, produced by the Nevada Coalition to End Domestic Violence and Sexual Assault, and the document Sexual Violence Advocacy, produced by the Rape Crisis Center. Now that the Advisory Committee has accomplished those two main objectives, ongoing monitoring of the work, we believe, will be better accomplished by consolidating the Advisory Committee on the Rights of Sexual Assault Survivors into the Committee on Domestic Violence in NRS 288. The Committee on Domestic Violence met and voted to consolidate ongoing functions from the Advisory Committee into their work and into their statutes. And AB 45 represents that consolidation. This consolidation is recommended by the Legislative Commission Subset Committee as well. The Attorney General's Committee on Domestic Violence has membership that is very much in common with the Advisory Committee on the Rights of Sexual Assault Providers, and the topics are similar and the same, very much similar, very much the same. And I think that was one of the reasons why you saw the idea that it would make for a more congruent and cohesive conversation to move these topics into the Committee on Domestic Violence. So with that, we'll do a walkthrough of the bill. So what you'll see in Section 1 is a retitling from the Committee on Domestic Violence to the Committee on Domestic Violence and Sexual Assault. That's important because this reflects the landscape of the work being done out in the community. All of the service providers but one are now dual service providers, meaning that they serve the domestic violence population, those who are the victims of that, and also those who are the victims of sexual assault. So the titling really reflects what the contemporary happenings are out there within the nonprofit and the service community. With Section 1, you're going to see that the titling and the name change is the majority of the bill with conforming language throughout. So Sections 2 and 3, Sections 5, 6, 7. The biggest changes you're going to see are in Section 4 to the board compositions and the board duties. So if you go to Section 4 to look at those, you're going to see that within the board of the Committee on Domestic Violence, there was the support to change the composition to add members to ensure that the victims of sexual assault were fairly represented in here as well. So we're requesting one staff member of a program of victims of sexual assault. Also, because we had previously 2 survivors were on the committee. We are more specifically designating that as 1 survivor of domestic violence and 1 survivor of sexual assault. We are also requesting 1 medical professional with experience in working with sexual assault forensic evidence kits. We thought that that position would be important to come over from the advisory committee. You're going to see also down in section 4, the duties of the board that we're carrying over. So on page 5, the new F1, 2, sub 1 and 2, G and H. So making recommendations regarding whether the needs exist for additional sexual assault victim advocates, and if such a need exists, create a plan for how the state can provide those, providing ongoing evaluation and implementation of the rights of survivors pursuant to the Sexual Assault Survivors Bill of Rights, identify the scope and nature if needed, make recommendations on how to fill those needs to the legislature for consideration, and review the effectiveness of statewide programs. So those were some of the duties within the advisory committee on sexual assault that we thought were the ones we absolutely wanted to keep and retain within this committee. You will see as well in section 9 of the bill that within section 9, it named previously and stood up a sexual assault kit working group. We would like to, that working group is no longer meeting. The Office of Attorney General worked diligently to address the backlog of the sexual assault kits throughout the state. Ongoing monitoring of that falls within the Department of Public Safety. But we believe that, but we do want to take the majority of Section 9 language there and add the Committee on Domestic Violence and Sexual Assault within there in replacing the Sexual Assault Kit Working Group Committee. So that's the majority of the bill and how that consolidation works. If we turn our attention to the amendment here, so the amendment is in Section 1. Within Section 1 of the existing NRS, it says there is hereby created within the Office of Attorney General the Victim Identification Notification, the Victim Information Notification Everyday System. The acronym is VINE, and that's actually a specific vendor product. And at the time, that seemed to make sense to name it in statute in, I believe, 2013. That no longer makes sense, so we would like to instead refer to it just as a victim notification system and not reference any specific vendor. And that, with that, we are open for questions.
Thank you so much. And it's so interesting because a member had just brought up this point to me recently. So I don't know if that member had a conversation with you all but I'm sure this member appreciates seeing this amendment right here. So with that, we will begin our questions. Our first question comes from Assembly Member Roth.
Thank you, Chair, and thank you so much for the presentation. My question is just practical. I'm looking at the, it looks like sexual assault victims advocate is defined in NRS, but on a practical level, are we looking at filling roles for, advocates who are showing up to hospitals, or these advocates that are going through the court process? Is that different? Like, what are the, what void are we trying to fill?
Great, thank you. Nicole Riley, for the record, NICOLEREILLY. Thank you, Chair Miller. And committee members. So the advocates are going to the courts and to the hospitals, and those are getting trained up. They're still community advocates. If they're based in the community, system advocates would be a little bit different. But as far as the sexual assault advocates, they're speaking to community-based advocates, and all of those are trained, whether they're going to the court or to the hospital.
Our next question is from Assembly Member Hanson.
Thank you, Chair. Thank you for being here, and appreciate the bill and what you're trying to do. Just to help me understand better, the Committee on Domestic Violence, and now, if the bill passes, and sexual assault, Currently, it does meet. It is comprised of members. I'm just curious, how often do they meet, and are you fully staffed with the existing members that you do have? I know you're asking for additional. Just trying to get a feel. We talk a lot about boards and commissions and committees, and I'm sure, hopefully, this is a very active and engaged committee, but would just like to hear on the record.
Thank you, Chair and committee members. Nicole Riley for the record again. The Committee on Domestic Violence is very active. Statutorily, we meet 3 times a year, one of which is in a rural community. And then we also, at times, based on issues identified or gaps, we do create subcommittees to work on those projects. Previously, we have had 3 subcommittees running along with the Committee on Domestic Violence and produced a lot of really great work across the state. We do have a couple of seats that we are looking to fill on the Committee for Domestic Violence. We'll be doing that this year. And then the members that we're requesting to add, which are representing the sexual assault population, we already have a prolific number of those available, and they actually attend the meetings as members of the public right now. So it would be very easy for us to fill those positions.
Not seeing any additional questions, I will go ahead and open it up for testimony in support of Assembly Bill 45.
Good morning, Chair, members of the committee. My name is Serena Evans, Serena Evans, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. When the Advisory Committee on Sexual Assault was created, I was fortunate enough to serve on that. We did some incredible work, but as Teresa mentioned, we fulfilled the duties, but sexual assault remains a huge issue here in Nevada, and so we are in strong support of continuing that work through the committee, through the Attorney General's office, and we are thankful that they brought this bill forward. Thanks.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELAKNOTT. We strongly support AB 45. As with domestic violence, victims of sexual assault need more support and resources. Too many times I've seen victims of sexual assault who are repeat victims of sexual assault. In the past year, I've had 3 cases where the sexual assault victim was a repeat victim. These were different victims with different defendants and different experiences. One victim was even a victim of domestic violence, and then a few years later was a victim of sexual violence. As with domestic violence, these stories are far too common. AB 45 will provide resources to sexual assault victims to help better understand their experiences, and hopefully we can find a way to break the cycle of violence. Support is needed to help educate those being victimized, to help end the cycle of violence that is both domestic violence and sexual violence. We need to help those who are trying to heal and to create a better life for themselves. Again, we fully support this bill and urge you to vote in favor of AB 45.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, Paloma Guerrero, Clark County Public Defender's Office. We see this bill doing important work in ending what can be a never-ending cycle of violence. In our work, we see firsthand how today's victims can be tomorrow's defendants. Many survivors, often acting out of trauma and desperation, end up entangled in the criminal system, whether through defending themselves against their abuser, being coerced into illegal activity, or simply having nowhere safe to turn. Without proper support, these individuals face cycles of victimization, arrest, and incarceration. This bill is smart on crime legislation that can lead someone on a path to safety and stability, ensuring survivors receive the resources that they need. Investing in support services is not just compassionate, it's smart policy that prevents future criminalization and promotes justice. Thank you.
Not seeing anyone in Las Vegas. Broadcasting, will you open the lines, please?
If you would like to testify in support of Assembly Bill 45, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in support at this time.
Thank you. I will then go ahead and open up testimony for opposition of Assembly Bill 45. Not seeing anyone here in Carson City or Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in opposition to Assembly Bill 45, please press star 9 now to take your place in the queue. There are no callers wishing to testify in opposition at this time.
Thank you. Then I will open it up for testimony in neutral. Is there anyone here in Carson City wishing to testify neutral? Not seeing anyone in Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in neutral for Assembly Bill 45, please press star 9 now to take your place in the queue. There are no callers wishing to testify in neutral at this time.
Thank you. Then I will welcome the bill sponsors back up for any final words. Okay, thank you. With that, I will go ahead and close the hearing on Assembly Bill 45. Next on the agenda today is public comment. We will begin here in Carson City and then move to the phone. So anyone wishing to make public comment can please come forward. Remember to state and spell your name for the record, and please keep your comments to 2.
Good morning, Madam Chair, members of the committee. Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. I'm here to let you know that we'll be reaching out to the Attorney General Ford. We'd like to put in a proposed amendment to Assembly Bill 63 and Senate Bill 66. And I have a letter I'd like to read. I am writing in support of the posthumous exoneration. My name is Ray Crone, and I have that personal experience in support of my position. I was convicted of a murder and kidnapping in Phoenix, Arizona in 1992. 10 years later, DNA testing, I identified the true perpetrator, and I was released. I am originally from Pennsylvania and was stationed in Arizona at Luke Air Force Base in 1980. After my honorable discharge, I got a position with the U.S. Postal Service as a letter carrier. I had worked there for 7 years, and at the time of my arrest, I had no criminal record. I refused a plea bargain. I was on trial for only 7 months. I was convicted in a 3-day trial based mainly on bite mark identification. I was sentenced to death. I was 35 years old. The majority of my family is all in Pennsylvania, a long way off, but they believed in my innocence and fully supported me for those 10 years. They gave me strength to survive such a harrowing ordeal. I was found innocent and released. DNA saved my life. I know just how fortunate I am. The evidence was not only made available, but it was available before I was convicted. I can tell you that the prosecution objected and fought this all the way to my release. They were wrong. But if I had been executed, my family, friends, and even the legal team believed in me and fought constantly on my behalf. They were convinced of my innocence and would not give up, even against the full powers of the state of Arizona. Do you believe they would have quit their belief in the determination to prove my innocence after my execution? No. I can guarantee you that. How would you feel if you were in their shoes? This is not a singular incident. Mistakes are made in our criminal legal system. I only ask that you recognize this as a definite possibility and allow for any unfortunate family of such a horrific situation the opportunity to prove their loved one's innocence after death. I thank you for your time and requested consideration, and this would also be applied for compensation for the families that they had gone through. Ray Crone was the 100th
Thank you, Ms.
person
Brown.
to be
We're over
exonerated.
time. Thank you so much. We're over time. Thank you. Anyone else wishing to make public comment? Not seeing anyone in Las Vegas. Broadcasting, will you open the lines, please?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now.
Anne Marie Grant, Advocates for the Inmates and the Innocent, ANNEMARIE. I just want to echo my colleague, Ms. Brown's statements and say that we have an amendment to AB 63, and we are informing the Nevada Attorney General about our proposed amendment to AB 63 today, and we hope that you all will support our amendment. Thank you.
Thank you. Next caller.
Chair, there are no other callers to provide public comment at this time.
Okay, thank you so much. With that, I will go ahead and close public comment. That concludes our agenda. Wait, hold on, maybe not. And now I believe that concludes our work for the day. So with that, I will go ahead and adjourn today's meeting. I will see you all back tomorrow at 8 a.m. This meeting is adjourned. Chief Benitez Thompson.